Wade? You get an idea of what you're in for here, don't you?
Well, I was thinking when I was hearing the argument that I made a mistake by leaving my flak jacket. It's a pleasure to appear before the court. I am David Wade. I represent the trustees and the other parties that are associated with them. My clients are not present in the courtroom, but they are attending by the live webcam. They live in Arizona. This is not an easy case. I really appreciate the way the courts protect attorneys, being one myself. The litigation privilege, the attorney immunity doctrine, all those are important considerations for what we do in life. We as representatives of clients stand up in front of courts, and we have a solemn duty to do our best for our clients within the rules. And we're not supposed to have to fear that we're going to be called to task because of doing that. This is a tough case. This is a claim by my clients against the Mitchells because they committed the torts against their client. It is a cause of action brought on the tort of another. It's a recognized cause of action.
Mr. Wade, can you explain why that cause of action is not related to, let's just assume that this involved, the right to petition and that it was, the attorney, that includes the attorney's right to petition. So let's kind of set aside those issues for a moment. And, you focus a lot on the cause of action that you bring, but I think we have to look to, the statutory language, which applies to a legal action that relates to the exercise, that party's exercise of the right to petition. So how does your client's cause of action not relate to the trust litigation?
It is certain that the trust litigations are evidence with respect to my client's claims, but they are not the gravamen of my client's claims. And I can go through and demonstrate that with respect to each of the 8 successive lawsuits that took place over 15 years. The cases, and admittedly, these cases are not Tennessee cases, but they're the ones that the courts looked at from Texas and California, as has been pointed out at the invitation of Mr. Perry. The courts say in this type of case, and I'm referring to the Cartwright Corporation case, it's a California case, that in a judicial proceeding that there may be oral statements that the attorney made in judicial proceeding, and the court may have standing to bring, the attorney may have standing to bring a slap action. The question of related to that you're asking me about is that the action brought by my clients is not related to the cases as such. It's related to what they did in treating Mr. Cartwright over the years, mistreating Mr. Cartwright, not telling him things, not reporting things to him.
But all that stemmed from the litigation, the cases. I mean, they wouldn't even have had a relationship with Mr. Cartwright absent that litigation.
Let me draw your attention to the litigations, because the words "in response to the litigations" is also part of the statute.
Yeah, and I think you might have an argument if all we were looking at is based on or in response to, but you can't read related to out of the statute. And so that's what I would like you to focus on.
You can't, but as I put, as Judge Davies said, rightfully so, he had to look at the allegations of the complaint to find out what the cause of action was. And he did that.
Counsel, is there any injury, though, here if there was never a filing? And if Mr. Alan Cartwright hadn't filed, then whatever he advised, whatever the lawyer, Mitchell's advised Mr. Cartwright would have no impact on your client.
That's true, Your Honor. But the fact of the matter is the damages occurred not because of the filing of the lawsuit as the cause of action, but because of the malpractice and the misleading and misstatements and deception of the Mitchells against Mr. Cartwright. In order to understand the parties to this action, first of all, the Mitchells were not on the other side of the V in any of these cases. And y'all have discussed that. What happened here, and which is why these cases, for instance, the Pretonic case says it's necessary to determine the gravamen of the claims. It's
Sorry,
not
what are you reading from?
Pardon me?
What are you reading from? I didn't hear you. I apologize.
It is called, I did bring my
You need to
glasses.
borrow mine?
I did bring my glasses, although I didn't bring my black vest. It is the Coratronic case, 192 Cal App 4th, 1381. Determining the gravamen of the claims requires examination of the specific acts of alleged wrongdoing and not just the form of the plaintiff's cause of action, the specific acts of wrongdoing. It wasn't the filing of the complaints. Now, there were damages caused by that, but it was not the filing of the complaints.
Let me interrupt for just a moment. You did not reserve time at the outset. Did you intend to?
How much time should I reserve? I did intend to reserve 5 minutes. Thank you, Mr. Givner. So it is important to look at the cases. What happened in these cases is there were 8 cases. First one was filed in 2004 in Chancery. It was the question of the improper administration of trust. That case was resolved by motion for summary judgment that the trustees had followed the trust documents and Mr. Cartwright had been paid everything he was entitled to under the trust documents. It was reversed on the limited issue of undue influence of some amendments to the trust. After that case was decided, Garner's, the trustees, did not file suit against the Mitchells. The next thing that happened is on remand. It was proven that the amendments that were being attacked as somehow being evidence of undue influence actually provided Mr. Cartwright $1.3 million more than he would have gotten without the amendments. And therefore, my clients, the trustees, were not enriched, but he was and suffered no damages. So that case was dismissed. My clients did not file any action against the Mitchells because of that. The next thing that happened was a circuit court case. They wanted to get the case out of Chancellor Golden's court because he had ruled against them. Circuit court has no jurisdiction in the administration of trust. That case was transferred back to Chancery, and Chancellor Golden dismissed it because it was not a circuit court case jurisdiction. My clients did not file a lawsuit against the Mitchells for doing that. Then they filed a federal lawsuit. Why? Get it out of state courts. In the federal lawsuit, they basically brought up the same allegations they had in Chancery. Judge McCullough dismissed the case because federal courts had no jurisdiction, said they rely only in Chancery. My clients did not file a lawsuit against the Mitchells after that case was filed. Then they filed a second circuit court action, which was also dismissed. My clients didn't sue them. There was a second Chancery court case in 2014. It was ultimately dismissed because of statute of limitations and res judicata. And by the way, before that happened, the Mitchells stood up in the Sixth Circuit in response to a question by the judge, how are you prejudiced if this case is dismissed? Because the Mitchells were arguing the federal court should abstain. And the answer to that question was, if you dismiss it, we're going to be barred by statutes of limitations and res judicata and other procedural bars.
So we are familiar with the underlying facts. Let me just ask you, Mr. Wade, you raised a number of issues. What do you think is your main issue? What do you see as the main determinative issue in your favor?
I am impressed by, for instance, Judge Golden's case in Roe, where he describes the absolute correct anti-SLAPP case. That's where the lady filed her claim of Title IX violations. The other side, the young gentleman, I'm assuming that to be the case, filed a lawsuit claiming that there was a defamation. Judge Golden says, no, that's exactly where it resides. The main point we're making in this case is that the Mitchells never petitioned anything that they were protected by, number one. Number two, what they did is the tort we're relying on. I was going through those 8 cases to show you that my clients never filed a suit against the Mitchells for filing those 8 cases. Never. They filed the lawsuit because after the 8th case, what happened is the Lewis Thomason firm withdrew. So
you are basing it on the in response to language in section 104A?
Yes,
Is
ma'am.
that?
Yes, ma'am, we are.
Okay.
And we are also not denying that there was a relation to the cases in the sense of they were the evidence of what happened, but they're not the gravamen of the claim.
Counsel, isn't it beyond evidence, though? I mean, it's the cause of the injury to your client. There's no injury to your clients if these actions aren't filed. And Mr. Cartwright got bad legal advice, let's say, maybe even unethical legal advice. But the only way your clients become involved in this is through the actual filing of the suit. So the cause of the injury is the filing, correct, in each of those cases?
Ultimately, well, let me not give you a roundabout answer, but I'm dealing with the tort. The tort involves a duty, a breach of duty, proximate cause, and damages.
I want you to stick close to the microphone. If your clients are listening online,
are.
they won't hear you.
Well, hello. Thank you, Your Honor. So, there's a duty. The duty of the lawyers is not to work against the client. The duty of the lawyers, they have a hallowed duty to protect the interests of the client, not to act against them. Not to threaten the client when he asks, can I quit these lawsuits, to say, no, if you quit these lawsuits, you're going to owe us hundreds of thousands of dollars. So there's a duty to protect the client. The allegations are they breached the duty. And yes, there was proximate causation. But in order to determine whether the case is related to the filing of these litigations, you've got to look at the gravamen of the case. And that's what Judge Davies did. And we cite the cases throughout California and Texas that say, to get to the first prong, you just don't decide there was a lawsuit filed, therefore the first prong is met. I mean, getting to your questions, you could go on forever and ever and ever, but you have to look at the gravamen of the complaint.
Why is that your position? I mean, from where are you deriving that complaint, other than out of jurisdiction case law? I mean,
There aren't any cases.
But where in the statute?
Pardon?
Where in the statute do you get that requirement that you have to look at the
I get
gravamen
it
of the complaint?
if looking at the need to be if a legal action is filed in response to a party's exercise of the right of free speech. Our legal action was not filed in response, this is 104A, was not filed in response to a party's exercise of the right of petition. It was filed because they committed malpractice, and the malpractice caused the damages. But it is not, the gravamen of the case is not in relationship to the filings of the lawsuits.
So how
That was a
do-
result.
How do,
Judge.
Mr. Wade, I'm trying to figure out how 104A and 105A work together. So I want to think it through with you a little bit. It looks, 104A says, if a legal action is filed in response to a party's exercise of the right to petition, that party may petition the court to dismiss the legal action. So that looks substantive to me.
I would
If
agree.
this is done, you may file a petition to dismiss the legal action. Then 105A appears more procedural to me. But the language is more broad because it does contain the relates to language. But it talks about the burden of making a prima facie case. So how does one, how do they fit, how do we view those two together? Does 105A broaden? 104A says you can petition the court to dismiss if a legal action is filed in response to the right to petition.
Correct.
But the language in 105A is broader. It has the relates to language, but it appears procedural to me. So
Well, it would, of course, far be it from me to try to suggest to you all what
Oh, that's
duty
your
is,
job.
What is, well, far be it for me to incorrectly suggest to you all that you, how to interpret a statute. But you don't interpret statutes to read something out. Now, it does, 105A does say it's based on, comma, relates to, or is in response to. But the in response to is still there, and it relates to that party's exercise of the right to petition. I guess that's one of the tough questions that we've got to deal with in this case, is whether or not
that's
there
why I'm
is
trying to
a-
get your help here.
I'm trying,
I'll be asking Mr. Pera the same question.
I have to say, Your Honor, I cannot get around 104 that says if a legal action is filed in response to, and that statutory prescription is definite, and it deals with the issue of filing something in response to the right to petition. We did not do that. I suppose I could come back to something that I consider to be extremely important, and I agree with Mr. Pera, which is unusual, but I do, where he said this is a unique statute. It is a very limited statute. And with all due respect, I believe it was enacted for a very specific purpose. It deals as the Roe v. Doe v. Roe, or whichever it was, the case that Judge Golden decided, that specifically addressed the claim and the response to the claim. The claim that claim was defamatory. In his decision, Judge Stafford said, well, isn't this the same as slander? No. A defamation action is endemic to the basic claim that was made. And that's why you look at this specific case and say, was that action filed in response to this
What's
action?
different about your argument than, say, a lawyer in a defamation case coming in and saying, it's not so much the words that were spoken necessarily, it's the failure to investigate, it's the failure to look
Yes.
into what was said, it's the fact that they were careless and reckless in terms of how they, and sure, what was actually said, but the underlying negligence is the failure of the newsroom or the speaker to look into it. And so therefore it's not under the TPPA, because what we're really targeting is that negligence. And this is just the cause of it was the spoken word. How is that different than this scenario?
I'm not sure I catch your drift, but I'll do the best that I can. We are targeting the malpractice. That was the precipitating event. My clients didn't know about that until 2018 and 19. Once the Mitchells released Alan Cartwright so he could talk to them. And you have to understand, Mr. Cartwright is a challenged individual. His sister's been taking care of him as the parents asked her to do, or made her do, as trustee. And so removing that communication, as the Mitchells did, made them blind as to what was going on. When they found out, then they discovered the cause of action. And it is very much a malpractice, and that was the tort. Our claim is based on the tort of another.
Well, going back to Judge Usman's, I guess, earlier question about, wasn't the injury, weren't the damages caused by the litigation itself, and kind of tying that to the example that he just asked, I mean, in that hypothetical defamation claim, it was the publication of the statement, the allegedly false statement, that would have caused the injury, that would have caused the damages, but, I guess what the lawsuit would be targeting in that hypothetical was the failure to investigate. So how is that? I mean, that seems to me to be pretty analogous to the situation.
Well, it's not necessarily the failure to investigate. Our claim is not that. Our claim is that they failed to tell him what they should have told him.
But in both situations, you have, the damages are caused by sort of one thing, but the allegations may focus on slightly different conduct that isn't actually the communication itself. I mean, that seems to be your argument, is that it's, what your lawsuit is targeting is not the filing of the litigation.
It's not.
It's all the stuff that was kind of swirling around that.
It is the tort that took place, and that's what our claim of action for the tort of another. Again, I'm going to come back to the Coratronic case. That case says when a lawsuit, maybe this addresses what you're asking me, Judge, when a lawsuit involves both protected and unprotected activity, and you're saying some of the activity may have been protected. We're saying the gravamen was never protected. That court goes on to say the court looks to the gravamen of the claims to determine if the case is a slap. Then it continues, and I quote, where the defendant's protected activity will only be used as evidence in the plaintiff's case and none of the claims are based on it, the protective activity is only incidental to the claims. We argue that that activity is evidence of the claim, but the claim is the malpractice, which had nothing to do with what the Mitchells did when they filed those complaints, because my clients never brought an action against them for filing those complaints. There's something that's very important in all of this. We're talking about, when it comes down to exercising the right to petition. My clients have exercised their right to petition. They have that right too. And when you look at this statute's set up not to curb meritorious claims, but it is to curb those specific claims which are in response to whatever the precipitating event was. So with that, I think, unless there's another question.
All right, thank you, Mr. Wade.
Thank you, Your Honor. It's nice to see you all. And yes, I've got 5 minutes. Thank you.
Mr. Hebner rescued your 5 minutes.
I should address it to you, but
It's all good.
thank you.
We don't usually get a second bite at the apple, Mr. Pira.
I am
But
second
you
bite
got
at
to,
Mr. Parrish.
you got to sit back
I'm
and
grateful for
say, oh, why did I say that? All right, I'll say, next time I'll say it more clearly.
Well, I'm grateful for all those bites. And I am Lucian Para. I represent the defendants, lawyers and law firms in this matter. As the court knows, by the way, this appeal has been consolidated below for at least for some purposes. And so I would ask the court to consider, as the court's comment just suggested they might, in this appeal, arguments that I have made previously in the other appeal as well.
Trust that we will.
I just thought I'd say so. What's this lawsuit about? Okay, in an effort to get around Tennessee's deeply entrenched American rule on fees, the Garners have sued on this unusual theory of tort of another. After all, they're not clients. They cannot sue for malpractice, even though that word was mentioned a lot by Mr. Wade. And remember, this case involves the parties on one side of the litigation suing the other side's lawyers. They won the litigation that's now over, except for a couple of still pending Rule 11 sanctions. Now, what are they suing for? You can get this from Judge Stafford's opinion very clearly. He spent a lot of time on this. They claim, the Garners claim my clients brought for their client, Alan Cartwright, allegedly frivolous and meritless litigation. And that the Garners incurred attorney fees and expenses in defending him. And the trial court observed, and here I quote, "In this lawsuit, the Garners are seeking to recover damages against defendants for the depletion and waste of the family trust assets and the attorney's fees and costs incurred by the trust in defending against various lawsuits." It could not be any clearer. Judge Stafford walked through that in some detail. The Garners have epic statute of limitation problems, as I'm sure was apparent for Mr. Wade's recitation of more than a decade's history of lawsuits. In any event, that's the claim on which the Garners wish to proceed, and that's the reason my clients filed a TPPA petition. We believe their claims are frivolous. We believe their claims are exactly the kind of claims that the TPPA is intended to provide an exit ramp for quickly. Now, let me jump ahead to the court's question, Mr. Wade, which is, I want to go to the core here. Now, I want to ask the court to, for a moment, but just for a moment, take the Garners' arguments about the limited reach of the TPPA in this case seriously, okay? So let's consider whether their actual claims, as pled, are as limited as they claim. Now, we heard a few minutes ago that Mr. Wade is no longer denying that these claims are related to the right to petition. That's what I heard him say. So I want the court to consider whether their actual claims as pled are limited in that they do not reach anybody's right to petition, because that's their position. So, well then, they're arguing that they simply have not pled and do not want to plead or need to plead or prove or seek damages for a lot of the conduct that we and the Court of Appeals believe they allege in their complaint. So I ask hypothetically, would they be willing to agree that they will not be permitted in this lawsuit to plead or prove or seek damages for the filing or maintaining of the trust lawsuits? For example, what if this court ruled in their favor, denying my client's TPPA protection, but at the same time entered an order that said it construed their complaint to not reach and denying them the ability in this lawsuit to prove or seek damages for the filing or maintaining of any of the trust lawsuits? Now, if they're serious about their argument, they should tell this court that that would be just fine. I don't believe they will. It goes directly to two of the justices' comments or questions about injury. I don't think there can be any serious question about what the plaintiffs in this case intend. And that's what Judge Stafford wrote. I won't read it all into the record, but page 10 of Judge Stafford's opinion in this case, he says there can't be any reasonable conclusion from reading the Garner's complaint other than it was filed in response to, or at the least relates to, the filing of the trust lawsuits. That's where he cites Webster's on relate. He goes on to say that the court has to conclude that the Garner's claim at least relates to a communication seeking review before a state government body as required by the TPPA.
Mr. Parra,
Yes.
I'm wondering if you could respond to the question that Chief Justice Kirby asked Mr. Wade regarding the interplay between 104A and 105A. That seems to be a difficult question to me. And, you know, it is different language. I think it's very difficult to argue that, you know, that the legal action is not related to, at the very least, related to the right, someone's right to petition. We'll kind of set aside that question for now. But
I applaud that formulation.
but, you know, 104A, it only uses in response to. What do you make of that? What should we do with that?
Well, first of all, I agree with the Madam Chief Justice's reading contextually of 104 as the right and 105 as the procedure.
See,
So-
I would maybe disagree with
Okay.
that, because I read 104A as just establishing who can file the petition. And, yeah, I mean, I suppose that's a necessary predicate to being able to rule on the petition. But I guess I see them as both being substantive. But I guess if A is the door through which anyone who wants to get
Has to go,
an
right.
action dismissed has to go, I suppose that is the more important of the, even if you view them both as
Right.
substantive, that's the more important of the two.
Right. And so, again, focus me back on
So you would agree
your-
with that? So,
I would,
yeah,
yes.
in A, I mean, you would agree that establishing that the legal action is filed in response to the party's exercise of the right to petition, or someone's exercise of the right to petition, is a necessary predicate.
I do.
Okay.
I do. And I think in response to,
But you think that's met here?
absolutely. I don't see how you could argue that it was not. In fact, my reading, as I recall, I'd have to go back and look at it again, is that the trial court found that as well, which is why the trial court was forced to create an exception. So we have two concurrent courts. I realize it's not a factual finding where y'all are bound by that, but nevertheless, you've had a judge who found an exception and denied our petition, find that it was in fact in response to and related to.
How do we, I mean, if we, a lot of the allegations here, right, are certainly related to the litigation, but, you know, they are not alleging that what was wrongful, right, about what happened here was the act. So some of the allegations are related to the actual filing of the litigation, but then there's some, you know, failure to communicate sorts of allegations. And how, you know, those are not communications, I think, within the meaning of the TPPA under the definition of the exercise of the right to petition. So anyway, I'm just wondering, you know, when you have a complaint that has a whole lot of different allegations, you know, how do you like, is Mr. Wade's proposed gravamen test out of bounds? Like, should we disregard that? And if so, why? But when you have a case that has a lot of different allegations and it maybe, you know, goes to different things, some of them relate directly to the litigation, some don't, what are we supposed to do with that?
Well, I am not going to accuse probably any other lawyer, but certainly not Mr. Wade, not in this case, or his clients, of being disingenuous. On the other hand, the point of my suggestion earlier about the scope of their claims is that I don't believe it's true, nor did Judge Stafford, in his opinion, a court's opinion, the Court of Appeals opinion, believe it was true that this complaint was not about the filing of the underlying lawsuits, the 5th and 6th lawsuit. And of course, bear in mind, it couldn't be about the filing of the prior 10 years of lawsuits. I mean, those are going to be gone. At some day before I die, those will be gone, okay? Because the statute of limitations does not permit that. But let's confine it to those 5th and 6th lawsuits. I don't think it's true, because if it were true, then we should have, this court should, if it's going to issue an opinion along those lines, it should forbid the complaint from being pursued beyond those limits. I don't understand how the court can evaluate the complaint on its face. I've always understood gravamen to not be, and maybe I'm wrong about this, I haven't looked it up, to be not only about the legal basis, the label that's put on it, but about the facts. There's no reasonable way to interpret this claim otherwise. Remember, they started with 2 claims, 2 causes of action. They reduced it to 1 in their amendment, and their only claim is tort of another. And yet, as you saw in the Court of Appeals opinion, they walked through in some detail the factual basis for that. That clearly gets you to a place where I don't know the right word, import, scope, meaning of the complaint they brought is about the filing.
I mean, what if you had, what if you had a situation, though, where, there was a malpractice claim where, the allegations really did focus purely on a failure to communicate that occurred during the litigation, but it wasn't about the actual filing of the litigation.
Right.
The lawyer filed the complaint that, it was a solid complaint, it wasn't frivolous, but there was some sort of communication lapse in the course of the litigation.
I don't.
Would that be in response to, and then there was a malpractice suit. In your view,
Right.
would that malpractice suit be in response to the exercise of the right to petition?
I'm glad you asked, because there's been a lot of loose talk here this morning about as if every malpractice case, legal malpractice case, would be covered by the TPPA. I don't think that's true.
Well, and that's
You
what we're
have-
trying, I think that's an important,
I
so
think
this is an important discussion, because I think that is certainly a concern.
I don't see how-
Where is the stopping point? So,
I'm sorry.
I shouldn't have interrupted.
No,
because
I'm sorry.
I really do want to hear your answer on this.
But you got to get past the sort of gating function of 104, right? It has to be filed in response to a party's exercise of one of those rights. I'm not sure I understand, and I haven't thought about it long enough probably, but how I understand what you're posing would trigger. So you're saying, let's say it's a malpractice claim over the lawyer not communicating effectively. Gosh knows the board gets those complaints all the time. Let's assume that's a malpractice complaint. And so the lawyer wants to file a TPPA complaint saying that the malpractice complaint over lack of communication is filed in response to his assertion of, or exercise of, a right here, free speech, petition, association. Where's the right?
So the conduct at issue, or lack of conduct, I
Right.
guess, the omission would have occurred completely out of court. It wasn't based on anything that actually happened.
I don't see how that's covered.
As a result of the lawyer filing something in court.
I don't see how that's covered by 104.
Counsel, could we say in this case that it's inextricably intertwined? There is no claim without the filing.
Correct.
Without the filing here, you can't have there's no way that Alice Cartwright can bring a claim.
But
That's
wouldn't the same be true in the example that I just posed to you? I mean, if you engage in that sort of but-for analysis, I mean, you wouldn't have a claim of a failure to communicate if the lawyer had never been retained in the first place and filed this action on the client's behalf.
Let me try to sort that out. I think factually, it is not credible, plausible, and I think Judge Stafford and the Court of Appeals got it right to say, look, we're reading the complaint. This is about the filing of the petition. It's about the right to petition. So you're positing a different question, I think, about without that. Let's assume that the suit is in fact about simply the fact that it's a stranger to the attorney-client relationship suing over the lawyer not telling the client something. There are causation problems, fine, let's set those aside for a minute. I don't see the right to petition there. I don't. I mean, I have to be candid with the court. I don't see it. But that's not this case. That is clearly not this case. And factually speaking, neither the trial court nor the Court of Appeals found that that is this case. I don't know if that's, I think that's responsive. A lot going on in the question.
No, that's responsive to my question. And I think that answers my lawyer brawl hypothetical, I
I
guess,
think
too,
it
right?
probably does too. It's hard. To spin up hypotheticals about this is very difficult, but I think it does.
Actually, I think it's pretty easy.
I think so.
So, using Justice Campbell's example of the communication is outside, I want to go back to the Chief's question, though, because you relied on 104. How does that play with 105? Because the communication would still relate to the lawsuit at hand. It may not fall under 104, but it could still fall under 105. Could it not?
I think it could, in theory. I think that's not where we are here, but I'm not trying to dodge your
I know, but I'm using Justice Campbell's hypotheticals. We have to look at it that way too. We have to look at it from all angles, so to speak, and figure out where this is all going to lie. And her example is the malpractice is not in a filing
Right.
improperly. It's just for whatever reason you didn't communicate, right?
Right.
And you're saying under 104 that doesn't fall under 104.
I don't, my gut reaction is it would not, but
Right. But the Chief Justice had the question of how do 104 and 105 play together? And if the communication is not the filing of a frivolous claim or something like, it's just some other communication between the lawyer and the client that is the basis of a malpractice claim, that relates to the lawsuit, does it not? So how does 105 play in?
sorry.
No, sorry.
No, I mean, it might in the sense, if you're suggesting that the language of 105A is broader in its sweeps up more than 104, I can see the argument for that. I do not agree. I think they ought to be read to reach the same thing.
So, okay, well then how do you read something that's very broad with something that's narrow and say they should reach the same thing?
I don't see what's narrow about 104A.
Well, I
But
thought
is
your argument, oh, I'm sorry.
So
Go ahead.
that's okay. I was just gonna- Isn't 104A the prerequisite for getting to
I thought so.
105A?
Okay.
Yes.
Okay.
And so that would suggest.
So
that
if
in a
you don't satisfy 104A, you're not ever going to get to
To 105.
I would think that that would suggest, and I have no Latin statutory construction accent to support that, but on the other hand, I would think that you would, if it is sort of the gatekeeping provision, you would read the supportive procedural provision to be consistent with it. I think. It's not quite subordinate, but I don't know.
It's a little hard to understand, I mean, it doesn't really make sense as to why the legislature would have included the broader language in 105A if, I think there may still be some problems with that. I don't necessarily disagree, but I'm just, I think it's just difficult to understand just as a practical matter, why you would have the broader language in 105A to begin with. It would seem to make interpreting 104A, I guess, as the gate through which anyone must pass to even, file a petition in the first place would just seem to make the broader language in 105A superfluous.
The truth is that this court is the first reviewer of this matter to have drawn this distinction between 104, or seen a distinction between 104 and 105. That's the candid truth, and I think all counsel would probably agree with that. The further truth, though, is that we do have some experience elsewhere on the subject before you in this case, in Garner. And that is, we have the Youngkin case from Texas interpreting a very similar statute. If you compare, we've done it in our brief, you can see it there. You compare the operative language, it is substantively identical. I've not heard anyone suggest otherwise. That was intentional.
Well,
And
it's
for-
not identical with respect to how it defines the exercise of the right to petition.
Well, okay, I'd have to look back at that. I'm
I mean,
not,
the court
disagree.
specifically says that, the definition of the right to petition in the statute is not kind of coextensive with it's broader than the
right, oh, right,
constitutional
I'm
right, so
sorry.
it doesn't even
I think
decide
that's,
that.
I think that's correct. I'm sorry, I'm probably out over my skis on that one. But the truth is, the plaintiffs in this case have cited no case from anywhere, no case law from anywhere that goes the way they want to go on this subject. That was noted by the Court of Appeals.
Counsel,
Right?
I do want to talk about
Sure.
one of the differences between
Sure.
the Texas statute and Tennessee statute. So in defining exercise the right to petition, Tennessee falls within the protection of the United States Constitution or the Tennessee Constitution. I don't believe the Texas statute
That
has
may be.
that language.
That may be.
So doesn't that bring us right back into our earlier discussion in terms of who's right and how that's playing out? And is there any sort of distinction to be drawn here between our earlier discussion and what we're looking at here?
I don't know that there is, to be honest. I don't know. I don't know that there is. I, again, think that that's surplusage in a sense. I mean, I don't see the need to distinguish. I'm not going to remake the arguments already made. You don't want to hear them. But I think either right is sufficient.
Mr. Para, is there any reason why this case should come out differently from the case brought by Mr. Cartwright?
I candidly don't think so. I do suggest that if you think about the hypothetical I posed earlier of the hypothetical lawsuit, Garner versus Cartwright and Lewis Thomason, that is instructive to think about whether this court is really prepared to rule in a way that says, yeah, we're fine with the TPPA providing a right on this language that we've all been struggling with all morning, provide a right to protection under the TPPA, which is, remember, a procedural protection. We're not abolishing anybody's substantive rights, but we're okay having a two-track case there. We're okay saying, yeah, we've got this expedited procedure that Mr. Cartwright can take advantage of, but not the lawyers in the face of this language. That's fundamentally what the court has to do, is all this analysis that we've been doing all morning about the language of the law. Okay, I mean, I certainly understand that if almost anybody in this room, I think at this point, had been asked by the legislature to draft this, at this point, they've all been educated so far, they would draft it with some more words in it. But you're faced with
We
the
would have
language-
asked that a long time ago.
Well, I understand, but, but it is what it is. The court is faced with addressing a mandate from the legislature. And the question is whether under the language we have with all the limitations it has, whether the legislature would have intended a different result in Garner versus Cartwright and Lewis Thomason than here. My answer is a very strong no. They would have said both are entitled to the protection of the TPPA. I think that has all kinds of public policy support. And I want to bring you back to the very beginning of my comments, which is our view is very strongly that this is exactly the kind of case that the legislature had in mind and the statute covers. It is a baseless claim, and that's not enough. That's not enough. It's got to be a particular kind of baseless claim. And it is that kind of baseless claim because it involves the right to petition. That's our view. That's our whole case. And I don't believe that it's really different when you look at either Cartwright versus Lewis Thomason or the Garner versus Lewis Thomason against that lens. I don't think there's any meaningful difference in the statute. Sure, it's different. I understand. But I just don't. And as I say, we do have actual case law from a sister jurisdiction that is on a materially identical statute. We actually got case law. And the other thing that's so, call it colorful or instructive, whatever you want, but they had the same problem with the statute down there, and they came to the conclusion we're asking the court to come to, and left it to the legislature, which then promptly fixed it. I was in this courtroom many years ago. I think it was Judge Tomlin in a public records case, and the city of Memphis didn't like the result that the Public Records Act came to. It was about leases on Beale Street, a case called Creative Restaurants. And I think it was Judge Tomlin who wrote, the law says what the law says. And if you, city of Memphis, this is in his opinion, if you, city of Memphis, don't like that result, if you say you're going to make the city uncompetitive in leasing out Beale Street properties, then you need to go to the legislature, not us. The legislature is, in his colorful phrase, Mr. Goodwrench. We're not. Though I understand this is the Supreme Court and not the Court of Appeals, the legislature has given this court language that, yeah, it's inartful. I understand you've probed every nuance of how inartful it is. But I think fundamentally it's very difficult to, in my hypo, come to a different conclusion in these two cases. I know it's a long-winded answer to your question.
Any other questions?
I think I am done.
Thank you, Mr.
Thank you. Appreciate your attention.
Mr. Wade, you have your 5 minutes.
Thank you, Your Honor. A few things. One, I just heard Mr. Parra in a couple of instances ask this court for an advisory opinion about what I'm supposed to concede to. I'm not sure what those questions were, but I can assure you I don't concede to. But, and Your Honor, we did cite the cases of Fikes and Ray, which deal with the failure of communications. And in our case, and the complaint, if you look at paragraphs 69 through 71, they are that the Mitchells failed, neglected to disclose, failed and neglected to communicate, failed to disclose their conflicts of interests and his need to obtain independent counsel. The Mitchells continued to pursue a series of lawsuits without making necessary disclosure to their client while under a duty to do so. Neither of the Mitchells told or explained to Alan Cartwright that he was subject to substantial awards of fees and expenses. Those are the torts. Now,
Mr. Wade, can I ask you a question about, you pointed to some allegations that, I think do really turn on the failure to communicate, and I'm just wondering if, in your view, is a TPPA petition an all or nothing situation? I mean, is there any precedent for a court kind of parsing out an action so that some of the allegations or some of the claims are subject to dismissal under the TPPA, but not others?
I haven't seen a case that said that, and I did cite to you earlier the case that said, well, there are maybe protected and non-protected. You got to look to the gravamen of the complaint to determine what the gravamen of the case is.
Which would suggest that it is an all or nothing.
But it didn't, I would think so. If it is the nature of the complaint that it is not in response to the exercise of the privilege of petition, if it is because of a tort that took place separately from all of those other complaints, then yeah, you got to look to the gravamen, and that would define where you go with the case, I believe. A couple of things Mr. Para keeps talking about. What if the trustees had sued Mr. Cartwright and the Mitchells? That makes no sense, because the claim was not against Mr. Cartwright because he continued to be the plaintiff in cases. It was against the Mitchells because of the tort they committed against Mr. Cartwright.
Well, but you can pretty easily imagine a situation where you have a pro se litigant, right? And then you have some sort of action. I mean, maybe it's not a malpractice action in that case, but there's some sort of action against the pro se. It's something against the pro se litigant, and you wouldn't have, in that situation, you wouldn't have this issue about whose right to petition is being exercised.
Well, absolutely, you wouldn't have that. I agree, because the private citizen's got a constitutional right to petition.
But
The lawyers
doesn't
don't.
that present a situation, I mean, this is, probably outside the malpractice context, but doesn't that create sort of the anomalous result where you could have the exact same conduct by one, in one case by a pro se litigant and in the other case by a litigant represented by counsel?
So the pro se, Mr. Cartwright, pro se sues the Garners. There's no independent tort here where the lawyers torted against Mr. Cartwright. This is Mr. Cartwright's action. I don't see the comparison, because we're not even dealing with the fact that Mr. Cartwright filed the lawsuit.
We would have to go outside of the facts of this case. I mean, it would be a different situation, but I'm just kind of imagining again, the claim would not be a malpractice claim. It would be something else, but you could have a situation there, I guess, where a pro se litigant might be able to get the action dismissed under the TPPA because it involved the exercise of his or her own right to petition, but the lawyer would not.
I think I can agree with that, but I'm not sure.
Yeah, I know, that wasn't a very, I didn't have a good understandable.
But finishing up, I got to finish up quickly. In the Loan Vest case, the court said a former client anti-SLAPP statute did not apply because the principal thrust of the conduct underlying the causes of action is undertaking to represent a party with interest adverse to the plaintiffs. In the Loan Vest case cited by Judge Davies, he looked at that and said, that's why we have to look at the gravamen of the case. So, yeah, I don't think there's an automatic stopgap, as Mr. Para might argue, that if there's a lawsuit that's filed, therefore, the anti-SLAPP statute applies. Remember, SLAPP means strategic litigation against public participation. That is not what this case is about. Thank you, Your Honors.
Thank you, Mr. Wade, and thank you to all the counsel in both of these cases. Very interesting cases, and we appreciate them. We appreciate, especially in these cases, the service as special justices, very special justices, Judge Dyer and Judge Usman. Thank you for participating with us, and the case will be submitted.
Thank you. Thank you, Your Honor. Pleasure to confer.